first case in the morning is State versus Yonkof, if I'm saying that correctly. You have everyone here, Mr. Smith, today. You ready to proceed?
Yes, we're ready.
All right, very good. In this case, it's only you, so you'll have 15 minutes to argue and no rebuttal time will be needed at that point. I'll be keeping time up here. I'll try to let you know about a minute left in your time if you get to that point. The arguments are being recorded. When you present your argument, please introduce yourself for the record. Please keep your voice up so we can hear you, and you're being visually recorded, so please stay behind the podium so we don't lose you on the visual recording. You should not use the name of any child, minor, or victim during the argument. You can refer to them by initials, a term like the child or something like that. I know it'll come up in the argument in this case, but if you would, please do. We read your brief and are ready to proceed whenever you are.
Your Honors, may it please the court. My name is Brian Smith. I'm here on behalf of the appellant, Adam Yonkof. Your Honors, there was one assignment of error in this case, which was that the sentence that was imposed by the Wadsworth Municipal Court was an abuse of discretion. The trial court failed to consider the sentencing factors under 2929.22. This was a case where the defendant or the appellant had a pretty much clean record. He had pretty much just traffic offenses. There was one case from 1998 that wasn't quite specified, but this wasn't a case of a repeat offender or someone with a significant criminal history of any kind. He was 63 years old. He was a business owner. Worked as a supervisor of a Mako body shop in Akron. And the circumstances of this case are also important. This was a situation. This was not purely a quote-unquote road rage situation. He acted out of concern for the situation. The incident began when there was a delivery truck parked on the road. It was parked in an unsafe place near a hill, where the elevation of the road made it difficult to see. And
Counsel, my understanding is the video is not in the record.
It's not in the record, Your Honor. There was a discussion of that there was a discussion of that. I believe the video was brought up, what's important is the trial court didn't consider the video because the trial court judge even mentioned, I didn't get a chance to look at the video and it wasn't part of the pre-sentence investigation process.
And that's what I was just going to say, and there is a pre-sentence investigation here, though.
Yes, there is.
Now, my understanding is there is a significant traffic record.
I wouldn't necessarily characterize it as significant. I believe there were a few traffic tickets, but it wasn't anything.
Were there any reckless ops?
There were a couple of traffic violations. I wouldn't necessarily. I mean, I guess significant is kind of a judgment call, but I wouldn't necessarily consider that significant. And and furthermore, it wouldn't necessarily be related directly to this. It would be the offenses were traffic offenses. So we're not looking at assault, disorderly conduct, offenses that would indicate that there was an issue with criminal proclivity of any kind. So I think the nature of those charges, whether they're traffic or criminal, I think that even if there is perhaps more than one, would have to be taken in.
You don't think reckless op would have any bearing on this case if he had a history of reckless op? I'm not saying he does. I'm just saying.
Not in this case, Your Honor, because I think what the trial court based its sentence on was that they believe this to be more a road rage type of situation. I think that was sort of underlying this, that the alleged victim made some statements that there was insensitive language or slurs that were used. So I think that was really the basis for the trial court's sentence here. So whether there's reckless op on his record, I don't think that would be an aggravating factor in this particular case, just because the type of charge doesn't match what the nature of the offense is in this case to which he pled. I hope that answers your question.
It does. Thank you so much.
Counsel, I apologize if this was in the briefing and I missed it, but Was the sentence stay for the purposes of pursuing appeal?
Yes,
Okay,
yes, there was a stay.
thank you.
And so the circumstances of this case are important. There was also a showing of genuine remorse here. He owned up to this action. He said, "I apologize. It's my fault. I take responsibility." So that's also a factor weighing against the imposition of the trial court sentence in this case, which included jail time. There's also a medical history there that I think makes a difference. It makes it to where he's less likely to reoffend. He had a history. I believe there was mention of a back injury. He had a history of medical treatment for a back injury, for hypertension. He's 63 years old, so this isn't a situation where someone's likely to go out and reoffend. It's a person who has ties to the community, a person with a history of stable employment, of being a supervisor. So this isn't a profile of a person who's likely to have a high risk of recidivism or having this type of offense reoccurring. So all of these factors make the trial court sentence in this case an abuse of discretion, given all of those circumstances. There was no likelihood of committing future crimes. There were mitigating circumstances for the offense itself. As far as the behavior, again, it's not something that there's a history of. There was no assault and battery. These types of offenses aren't present in the appellant's criminal history. So we would ask that this court reverse and remand for resentencing based on and find that there was an abuse of discretion in this case. And I'd be happy to take any further questions with my remaining time.
Seeing none. Thank you for your presentation this morning, Mr. Smith. On behalf of the court will take the matter under advisement and issue a decision in due course. When that decision is reached, it will be mailed to you by the clerk of court and also available at the High Supreme Court website.
Okay.
Thank you.
Thank you, Your Honors. Have a good day.